Good evening. This is Rahul Reddy live from Houston, Texas. Every Tuesday, we do bring in immigration updates. Along with me is my business partner, Emily Neumann. Emily, what do we have today to discuss?
Yeah, today we want to start off talking about the tech layoffs. We have more and more coming. We have recent announcement of Amazon laying off people. And when these layoffs happen, it's not just US workers being laid off. H-1B workers get laid off too. So what does that mean in terms of the $100,000 fee from President Trump's proclamation? How these layoff situations are going to cause people to potentially need to travel outside the US, and then who does that $100,000 fee apply to when you're trying to get back to the US in H-1B status when you land that new job. We'll also talk about the common situation where people have to travel abroad and stay for a longer period of time while they have a valid H-1B. And what happens when they're returning to the US? What do they need to be prepared for if they're using that existing visa stamp to return to the US after a long stay outside the US? We'll also talk about traveling on the STEM OPT, what to be aware of when you are traveling, what types of risks there are, what can happen, what questions can be asked at the port of entry. And lastly, we'll talk about the government shutdown. What are steps people can take if you are impacted by the shutdown because you're not able to get your LCA needed for an H-1B, or you're not able to get your perm filed, or you're not able to get your perm approved in time to be able to qualify for an H-1B extension beyond the 6-year limit, or things like that. So lots going on with everything in the government right now that we'll try to answer questions as best we can.
Emily, right now, previously, when people used to get laid off, we used to tell people that B2, change of B2, if they are eligible for H4, they could change for H4. And then we also were told people that, hey, you can always go back to your home country and come back any point of time in the next 90 years. If you have unused H1B, or if you have an I-140 that's approved, you can always come back without any problem, and you don't need to be counted to the H1B lottery again. But now that's in danger, because if they go outside the country, they cannot come back on H1B unless the company is willing to pay $100,000. So what are the options they have right now?
Yeah, I think because of the $100,000 fee applying to any kind of petition that involves consular processing, we need to do everything we can to avoid consular processing. So main idea there is to change status to something else in order to buy time to be able to change status back to H-1B when you land that next job. Because when you're changing status from within the US, the $100,000 fee does not apply. So that means the B2 is still a viable option where you can file that change of status, get an extra 6 months of time in addition to any 60-day grace period that you may qualify for. And then at the end of that 6 months, or when you find that next job, you can file the change of status back to H-1B and not have to worry about the $100,000 fee. Same thing works if you qualify for an H4 or an L2 or any kind of dependent visa. We have some people that are looking into switching to F1 in order to continue their studies. That's also a viable option. The main thing is leaving the country may not be a viable option unless you or your new company is willing to pay the $100,000 fee, or you may qualify for one of these very limited exemptions.
So definitely living in, and you have 60 days of grace period, assuming your 797 is still valid for you to file the B2. You don't have to hurry up and file the B2 immediately. So let's say, for example, if you got laid off on October 28th, and you have until about December 25 to file a B2 application, assuming your H1B is still valid until December of 2025. So what you could do is you could file a B2 starting from December 25th. And you can do that online, though, and you can stay up to May 20th or so, May 25th or so, you can stay in the country. And in the meantime, if you get a job, you can always convert back into H1B without going through the lottery system and without subject to the $100,000 fees. So that's the best option. Leaving may not be a good option right now, especially because of the $100,000 fees that are being imposed, especially if you're outside the country, your passport is not yet stamped. If new company wants to file a H1B while you're outside the country, they are subject to the $100,000 fees. Even though you may have an I-140 approval, even though you are already counter toward the H-1B. If you're outside the country, you don't have a passport stamped, visa stamped already there, you are subject, or your passport visa stamp expired, you are subject to the $100,000 fee. So definitely consulting a lawyer if you get a layoff, discussing the options early in advance is much better though. Anything else, Emily, before we go to the next one?
No, so what happens when someone, needs to stay outside the US for several months and they've been maintaining H-1B status, their company's allowing them to work remotely from their home country, for example. They have a valid visa stamp. Can they come back to the US? Are they facing any troubles at the port of entry?
They need to be careful when they are coming into the country, though. Especially, let's say, for example, you're outside the country for more than 4 months, and you're coming into the country. The Customs and Border Protection people, what they're concerned mostly is, do you really have a job with this particular company? If you really have a job, how come 4 months you're not outside the country? So definitely a letter from the company showing that you still have the job. And if you are working, and if you're still working, continuously working with the company, make sure that the pay stubs are available and the bank statement reflecting the pay stubs have been deposited into bank account is really an essential aspect when you come into. And also, if you can tip off the HR that they may be receiving a call from the CBP at the port of entry. Luckily, most of the time when you come on international travel, especially from Europe side, you are entering into the country in the afternoon timing. The HR should be available at that point of time. Tip off the HR that they may be receiving a call from the CBP office inquiring about the job, and make sure that they will respond appropriately, be available at that point of time. Those are very crucial when you're coming into the country. And now there are some rumors, some people saying that, hey, you cannot work on H-1B in India. That's a very wrong statement. You are in a foreign country. If you belong to that particular country, let's say you belong to Egypt, and or if you belong to India and you travel to that particular country, you definitely, if you're going to the home country though, where your citizenship is, you can work from there. Absolutely not a problem. You don't need to have an LCA from Egypt or from India for you to continue working for the company. As long as the company allows you to work remotely, we don't see any problem whatsoever at all for you to work. But if you're coming after a long time, that means especially after 3 months, 4 months, or 5 months, we want you to be very careful to have the pay stubs together, HR ready, and a job confirmation letter from the company confirming that they still have a job, the underlying job for which the H-1B has been filed.
All right. How about traveling on the STEM OPT? So at this point, people have already graduated. They've already been working for 1 year on OPT. Maybe they've had some unemployment time. Now they're on their STEM OPT working for that E-Verify company. And is it safe for them to travel abroad? Is it a good idea? What if they need to get a new visa stamp? Is it even possible to get a new visa stamp when you're on STEM OPT?
If they have completed their 5 years of education, especially those people who have completed the bachelor's degree, though, by the time they go to the STEM OPT, their stamping is over. They have to go for stamping there in their home country to get back into the country. It is suicidal. I mean, it's practically they may not give you the visa stamping for you to come back on a STEM OPT because they assume that after you complete your education, you're going to go back to the home country. Since you already completed your OPT and your STEM extension, though, it's very unlikely that the consulate is going to give you the stamping at that point of time. Assuming your stamping is still valid, still, Emily, I don't feel comfortable people traveling. I have seen a lot of these people questioned how their employment is from the time they get OPT until the time they're returning. We have also seen that with artificial intelligence and things are taking over technology a lot. We are seeing a lot of layoff. When these people are outside the country, they're getting laid off, especially when they find another person doing the job, they're getting laid off. And that may also become a problem when they're trying to come back into the country. What's the purpose why you're coming back into the country? If you were ever to travel on a STEM OPT, if it's a real emergency that you need to, I would recommend strongly to consult an immigration lawyer. When you consult an immigration lawyer, I want you to provide the pay stubs from the time you worked all the way to the time that you have a consultation, W-2 forms, bank statements, and see if there is any unemployment gaps. I have also seen, Emily, that you have told many times on the OPT, you could work on a unpaid internship. You have told many times. However, some of the CBP officers are confused that these people could work and have given trouble, especially in the Abu Dhabi airport and Chicago airport. I've seen some trouble for them. So, if there is any unpaid internships that they have done, and that is also a concern for me when they travel, though. I would definitely tell them not to travel. And if they were to travel, carry a memo from the immigration lawyer that they are allowed to work in that unpaid internship only in the OPT period. In general, do not travel. If you were to travel, make sure you have every document available. Show it to an immigration lawyer. Let him do an independent review to see if that guy would allow you to go outside the country. Any comments, Emily?
Yeah, I think a lot of times we see when you are outside the country for, a few weeks, a few months, that time can be considered towards the unemployment time. And so if you've already used up a major portion of your unemployment time previously, and now you're coming back and you've been outside the country to a point that would take you beyond that unemployment limit, you could potentially not be allowed back into the country because you've exceeded the unemployment limit. We know that there is a lot of, or at least has been, a lot of people looking at F1 students. We had all the issues with SEVIS terminations at the beginning of this year, looking into any kind of criminal history or more law enforcement interaction more than anything, even if there was no arrest or no conviction. So if you have any kind of law enforcement interaction, that can be problematic, as well as any unemployment time, or as you mentioned, unpaid internship time that can be treated as unemployment time. Travel is not a good idea during the STEM OPT time.
Government shutdown, Emily. Right now, we cannot file the LCA. We cannot print out the LCA. We cannot file the H-1B extensions. We cannot file the H-1B transfer. People get laid off, moving to company B from company A. We can't file a H-1B amendment. What are the options that are available right now? If you are in a situation because of the government, we know, everybody knows that the USCIS is open. It's just the Labor Department that is closed right now. What are the options available for people when their H-1B extension is expiring, or when they are nearing the 60 days of the unemployment period and they have a job offer, but the company is unable to file? What are the options for them?
Yeah, I know there's a lot of people talking about, well, we'll just wait it out and file late when the government reopens, using the nunc pro tunc argument, which we've used many, many times over the years. We've used it in previous government shutdowns as well. The problem with that, the nunc pro tunc, so let's say your H-1B is expiring next week and you're not able to file your H-1B extension by the time your I-94 expires, but we know the government has said that they will treat a government shutdown as an extraordinary circumstance when you are requesting that nunc pro tunc extension and filing late. However, when you do finally file late, there are other parts to the nunc pro tunc argument. It's not just about the extraordinary circumstance. The delay has to be commensurate with the circumstances. You can't have violated your status, and it's discretionary. What if you wait, file late under this so-called policy, and then USCIS uses their discretion to not approve the nunc pro tunc? They're going to approve your H-1B transfer or extension, but without the I-94. That converts it to consular processing. Now the $100,000 proclamation fee kicks in for you to exit, not to be able to get back into the US. So that's a very big risk to take, by just waiting and relying on this nunc pro tunc. On top of that, if you are planning to file late, letting your I-94 expired or letting your 60-day grace period end, we know USCIS is claiming that you can file late and use this nunc pro tunc, and the government shutdown's an extraordinary circumstance. But how does ICE feel about someone staying with no I-94? They're going to look at you, say you get pulled over or something by these masked people that are out there in these cities, and you don't have any documentation. what are you going to provide them to show that you're lawfully present in the country? Because you're not. You don't have anything. You can't say, oh, my employer's planning to file and blame it all on the shutdown. Um, so I think that's a pretty big risk, and I would not rely on the nunc pro tunc alone. There are other people suggesting, hey, we'll just file it without the LCA. I also don't think that's a viable option. Number one, whenever you file without an LCA, even if you make it past the mailroom and they receive your petition, um, you are going to end up with a denial, because the first thing they will do is send you a request for evidence saying that you filed your H-1B petition and it lacked a certified LCA. Please provide a certified LCA. Well, when you respond back with a certified LCA that was not obtained until after you filed your H-1B, the only answer is a denial. It will be denied because you did not have an LCA at the time the petition was filed. Now you're potentially unlawfully present because you've got an H-1B denial after your previous I-94 expired. Um, so I think that's a big risk. And also, if you're filing this petition without a certified LCA, thinking it's going to extend your work authorization under the 240-day rule, I don't know if you're really authorized to work because you don't have an LCA supporting your employment. You need to have a valid LCA in order to be considered to be maintaining your H-1B status. So I don't think filing without an LCA is workable option at all. What does that leave us with? If you are at a point where your I-94 is expiring and you're not able to file your extension, file a change of status to B2 or H4 or F1, any other category that you might qualify for. Once the government reopens, get your certified LCA, file a change of status back to H-1B. That way you've maintained your lawful presence the entire time. You don't have to worry about making a nunc pro tunc argument, and you don't have to rely on any kind of, you know, discretion from USCIS. The downside is you can't work during that time period if you're switching to H4 or B2 or something like that and don't have that work authorization. But at least you are not kicking in that $100,000 fee, and you're not running around without a valid I-94 or any kind of documentation to show ICE in case you're stopped.
Anything else, Emily, before we go to questions?
I think we can move on to questions.
Shailesh from YouTube has this question that is it safe to travel in advance parole? There is a rumor that that somebody was being turned back and sent back because they have an advance parole. There is no truth in it. Absolutely, there is no truth in it. If anybody is there, please, we have a free consultation for any art things, guys. Please have them send an email to info@rnlaw group, but we don't want to speak with somebody, second party. We want to speak with a person who actually got affected. And we can call any number if they are in India, if they're in Egypt, whatever country they are in. We can call them. Absolutely not a problem. So definitely with advanced parole, no issues. Now you have to understand one thing. Let's say somebody has some drug conviction and now they are coming in advanced parole. They would be sent back. I mean, there is a problem. You have bought some, they would be sent back. So they would be sent back. So when they sent back, they're not going to tell guys to you and tell you guys that I was being sent back because I have a drug conviction. They won't tell you. They will tell you, oh, they're not allowing, they're not allowing, they're not allowing advance parole. That's what they will say. So be careful with these things when they are telling all these things. So if anybody is there, any odd things like this ever happen, please, we have a free consultation for them for this kind of odd situation.
Kieran Kumar says, are there any issues with filing a concurrent H-1B with this new $100,000 fee rule? No, concurrent H-1B are typically in the US and filing it as a extension of stay, which means that you're going to be getting it approved with the I-94, and the $100,000 fee does not need to be paid in those cases, even if you later travel.
Question from question that is coming with regards to random shots. And also question coming from Rick. He's asking, is the EB1A better, faster to get a green card, or EB1C better? Wow. If you're eligible for EB1C, definitely EB1C is an option. But if you have to go outside the country and come back, as compared to getting the EB1A, you don't have to leave the country. For example, if you're working for company A, you never work for company A's branch outside this country, you will not be eligible for EB1C. If you are eligible for EB1A, and you can file EB1A get it. So whichever gets you faster. Now, if you must be eligible for EB1A, eligibility is very tough job. If you're eligible for it, go for EB1A because it is not linked with the employer. It is not linked with your employment outside this country with the same company. So could be EB1A could be fast. The same question is related to random person. This is random shots. He's asking the question, can I just go outside the country, work for the same company that I'm working for 1 year, and come back and do the EB1C? Yes and no. Answer to that. It's not that easy that you just go and work for the same company and come back and get the EB1C. You must be in a higher level executive position. You must be supervising a good number of employees there outside the country and once you come back into the country. It's always good when you're embarking on such a big journey, it's always good to consult with an immigration lawyer to see if you are eligible for it. Now, if you are even eligible for, is your company willing to do all these things for you, or is the company not willing to do it? So those two things are very important for you before you go outside the country and come back in.
Sai says, my priority date is 2016 June and EB2. How long do you think it will take before 2016 becomes current based on the latest data from USCIS? So I had been sharing our predictions. Again, we're terrible at predicting these things, but we do our best. That was based on data from USCIS from June 2025. They did recently update it as of September 3rd, 2025. So we do have more recent information. And so even after almost all of the last fiscal year finished, we only had 27 days left after we got this data. There were still 43,000 EB2 and EB3 India 485s already filed and pending. So all those people had priority dates before you in 2016 because all these people had priority dates before January 2015, which was what that EB3 date filing date got to in October 2020. So if we have 43,000 people we know for sure are in front of you, that's just to get to January 2015. Then however many people it is between January 2015 and June 2016, that's another year and a half. But to get through 43,000 applications when they can only approve 5,600 a year because of the per country cap, that's going to take still another 7.5 years. So it's not, even though people are seeing movement because October came around and we saw the filing date move forward, that doesn't mean that that date is going to keep moving forward. That filing date is probably not going to change again until October 2026. And again, it's only going to be a small amount until we finally get to January 2015. It might be 7 years before we get to that point. So not a fast process.
Travel science gentleman is asking this question, that is it, do you have biometrics when you travel outside United States and when you come into United States? Now, I have noticed definitely when you come into the United States, if you're a non-immigrant visa, they do take the biometrics before you come in. Biometrics, you have to put the fingers and then you have to look into that. That's biometrics, guys, and that's pretty standard routine. When you're going outside the country, I haven't seen them doing anything. It's just like airport, like local airport. I didn't see anybody doing biometrics though. Now, having said that, when I spoke with people though, especially in the CBP and allied department people though, they right now have very sophisticated system of eye detection, who is leaving the country, who's entering into the country. In fact, they said we don't need passports anymore. I have traveled to United States a couple of times from outside the country. A couple of times, the officer did not even check my passport. When I went to the line, Rahul, you can go in. He did not even check my passport. How did he call me, Rahul? I mean, I don't work with CBP that much that I don't have a lot of deportation cases and the officer doesn't know. And he's doing the same thing with everybody, though. In fact, my wife has traveled into the some TSA or something approved one, and I went into the normal line. I was first to get in because they were able to read my face, and then that's it. They told me to come in. So they are monitoring the people, though. When you're, I am assuming that when you're leaving the country and when you're entering the country, definitely they're monitoring. When you're leaving the country, I'm assuming they are. If they're not monitoring, they will start monitoring. They may be monitoring in some places, may not be in all places. They do have, when you book a ticket to outside the country, that information goes automatically to the CBP office, to the immigration, that you left the country. You can see that on the I-94, it reflects that you left the country, you came back whenever, and the travel history is already there. Sometimes it may not reflect the actual truth in there, but most of the time it does reflect. So that means that they are monitoring when you're leaving the country and they are monitoring when they are coming into the country.
A couple people have questions about the $100,000 proclamation. So Vivek says his sister-in-law's H-1B got picked in the lottery this past year in 2025, and it was approved. Now she's in India, never traveled to the US, wants to go for stamping now. Does the fee apply to her? No, because her petition was filed before September 21st, 2025. It does not apply to her. And then Jatin says, is an H-1B transfer from employer A to employer B subject to the fee? No, it is not. You're inside the US if you're filing a transfer and you're requesting a transfer and extension of stay. Extensions do not require the fee unless you're found to be ineligible for the extension because you violated your status or failed to maintain status or it was filed late and you end up with a consular processing approval, then the fee would kick in once you leave the US.
Satish has this question that a person has moved from OPT to H4 and now they want to file a H1B lottery. Are they subject to the $100,000 fees? The answer is straightly no. If you're within United States, this $100,000 is not applicable. So even if you're moving from OPT to H1, H4 to H1, L1 to H1, the $100,000 is not applicable.
And Anirban says, how safe is it to travel with an H-1B that's stamped these days? I still don't recommend it. Traveling already having a visa stamp, people are doing it. It is possible to do, assuming that you don't have any law enforcement interactions, assuming you don't have any status issues in your past, you're working for a solid company, all those things. A lot of people are safely able to travel in and out using their existing visa stamp. So for those people, the big risk is what happens if you're outside the country and the next big proclamation happened? And think about all the people who were outside the country on September 20th, 2025, when the proclamation was announced, and it was unclear who all it applied to. People were scrambling to try to get on flights to get back into the US before that midnight deadline. You don't want to be in that situation. And we do see with the Trump administration, these proclamations come out of left field with no warning. We've seen it time and time again. They're just getting started. We're only a few months into this presidency. So although, yes, people are able to travel if they have a valid H-1B visa, there are a lot of people that are safely traveling. Still, do I recommend it? No.
Shailesh has this question. He has 4 traffic tickets in 10 years. 3 of them were being dismissed by defensive driving courses. I'm assuming that the fourth has been paid the money, means you have addressed it, whether you do defensive driving or you pay the money, you have addressed it. Do you have a problem on filing a 485 application? Absolutely not. I'm assuming that these traffic tickets are just speeding tickets or relatively those things, they are not DUIs, then you absolutely do not have any problem in filing the 485 application.
Toy Zone says, I'm on B2, received an offer, but the company says the H-1B transfer is delayed because the LCA cannot be obtained during the government shutdown. Is there any LCA waiver or way to expedite the transfer? No, there's not. I don't recommend filing a transfer without an LCA. It's likely to be rejected in the mailroom. Even if they do accept it, you're likely to get an RFE asking for the certified LCA. And if it's certified after the petition was filed, it will be denied. So no, unfortunately, you'll just need to wait it out. You have the B2 pending, so that gives you 180 days, assuming you requested the full amount of time. So just wait and file the change of status when the government shutdown is over.
I need to transfer from H4EAD to F1. Are such cases getting approved given the government shutdown? This question is coming from A from YouTube. The answer is absolutely. People are getting the F1s approved. No problem with it. You can even file in premium processing to get the F1. We do not see any problem in that. Lucky from Facebook has this question. If a B2 visa holder wants to move to H1B, is the 100,000 fee applicable? It's a bit complex here. The timing of the B2, because the lottery system happens somewhere in March and it is starting in October. So if somebody's entering into the country or with the purpose of moving into H1B, though, they may create a problem saying that, hey, let's say, for example, you enter in February and then you apply in a March and you get the lottery, and then you extend the B2 because from March they only give for 6 months. You extend the B2, that's a problem because you first of all you file the H1B within a short period of time after you enter into the country. So you have a preconceived intent of filing the H1B. So they may deny the change of status completely, and then you will be subject to the H1B. You will be subject to the $100,000 lottery. What if you already had a H1B before, and now you're traveling into the country on B1? They may consider that you traveled into the country for the purpose of getting the H1B. So it's a preconceived intent. They may deny the change of status. I'm just telling there is a possibility. So definitely, if anybody has any of that intention, it's always good to contact the immigration lawyer to see how the things will work. Now, you cannot come into the country with an intention of applying an H1B, but enter into the United States on a B1, B2. That is a problem there too. So definitely consult an immigration lawyer. It's not an easy question that we can answer it in one line here.
Ash says, can I travel alone for my H-1B stamping while my H-4 dependents remain in the US? They have valid I-94s, approved petition. The previous visa is expired. Technically, yes, I would say number one, we don't recommend travel if you need to go for visa stamping during the Trump administration. There are chances that you might get stuck and now your dependents are stuck in the US without you. Probably not a good situation to be in. Number two, I think it depends on the purpose of the travel and the length of the travel. If you're going for a 1 week business trip, no problem at all with your dependents remaining in the US while you take that business trip, and you can go for stamping while you're gone. However, if you're going to travel outside the US and stay there for a year to take care of your elderly parents while your H-4 dependents remain in the US. That's a completely different story and not an option. The whole purpose of your H-4 dependents being in the US is to be with you. And if you are not in the US because you are taking a long trip outside the US, they really can't stay here for an extended period of time as well.
Question coming from Madman. He has a DUI in 2010. He wants to file the H1B extension. He may be filing the I-140 again. Is that going to create any problem for him? Are there any changes in the law right now? When you file for the H1B extension, they will call for the biometrics. When you call for the I-140, they may call for you the biometrics. But as such, for the DUIs, people, we haven't seen any problem in extending the H1Bs or getting the I-140 approval. Now, there is another guy, Sai Kumar. He has a domestic violence case, which is dismissed by delaying sentence, which will the H1B transfer be denied because of this history. Domestic violence is considered to be a crime against moral turpitude. If it is, we have to look into very carefully. So it's a deportable offense, though. Definitely, when you file for the H1B transfer and extension, they will call you for the biometrics. I want you to consult an immigration lawyer, have a memo with you, make sure you discuss with the immigration lawyer, have a memo with you. And there is a chance that they may even detain you also in the domestic violence. So we need to look into very closely if you have admitted to the crime. Normally, we look into the police report to see if there is any statement made by you admitting the crime. So definitely consult an immigration lawyer before you even file the H-1B extension. So whenever these things are happening, the company lawyers are telling guys to have a private consultation because they don't want to deal in the criminal activities because they work for the company. So you may want to consult before itself, before you file an H-1B extension, H-1B transfer. What is the consequences, especially if you have a domestic violence thing?
Hamza says a transfer of underlying basis was not filed by me or my attorney. And both of my dates are current, EB2 and EB3, and USCIS approved my case under EB2, even though it was filed, I'm assuming, in EB3. Any concerns there? No, no concerns at all. We saw this happen a lot in 2022 for cases where they had filed in EB2 and the EB3 was current, EB2 was not, but the USCIS officers saw they had an EB3 I-140 approval. They just went ahead and approved it in EB3 without us requesting. We were concerned at that time because the case was not current in the correct category. We reached out on several cases to the Ombudsman office. They were able to confirm for us that USCIS actually knew that they had another approved I-140 and they utilized that one on their own. So no concerns about that at all.
Question with regards to my H-1B has been approved. I-797 is valid. This comes from Dhruv's World from YouTube that H-1B is valid. I-797, can I go to Mexico or Bahamas for a cruise and come back? The answer to the question is for Mexico, we don't have a problem. For Bahamas, the automatic revalidation for H-1B is not eligible for it. So Mexico is fine, Bahamas is not fine for the H-1B guys. So when you're planning a trip, if you're going for a cruise and you don't have a passport stamping already valid in you, don't go for a cruise to Bahamas. But if you have H-1B, if your passport is expired, your H-1B I-797 is valid, you can go to Mexico and come back even though you don't have a passport stamping. If you have an I-797 that's valid, you can go to Mexico, but not to Bahamas.
Krishna says, can my H4 EAD spouse work during my H1B severance period and during my 60-day grace period? Yes, they can. That H1B grace period is considered to be actual H1B status, which means your spouse is considered to be still maintaining H4 status during that time, and therefore they can work if they have an unexpired EAD during that same time.
Can I go out of USA and F1 OPT first year? Yeah, technically you can, as long as you have the proper employment, you have the payroll records and everything. But make sure you have every document that is there when you're coming back into the country. If there is any unemployment period which is crossing the 90 days, or if you have any unpaid internships at the point of time in the OPT period, we recommend not to travel.
Nathika says, would you suggest applying for an H-1B extension using an LCA draft while waiting for the government to open up? No, I do not recommend that for my clients. And the reason is, number one, a draft LCA is not an LCA that supports your continued H-1B employment. So you don't have employment authorization to keep working during the 240-day period, even though you filed an H-1B extension because it's not supported by a valid LCA. On top of that, when you actually get that certified LCA, it's going to be dated after your petition was filed. So when USCIS, which we know they will, send an RFE asking for the certified LCA, and you send back the one that was certified after you filed this extension, they will deny the extension. They cannot approve an H-1B based on an LCA that did not exist at the time of filing. For any petition filing with USCIS, you always have to prove that you met the requirements on the day of filing, not just on the day of approval. And they do, it's very black and white in that situation. Never seen them approve an H-1B with an LCA certified after the petition was filed.
Ice Dragon, I'm outside USA for past 1 year, wanting to return to USA with my existing valid 797 and H1B stamping. Um, how to do it? Definitely, you need to consult your immigration lawyer, maybe your company immigration lawyer or a private immigration lawyer. I definitely want a very good assurance that you have a job for you still left there and a very clear explanation why you were absent for such a long period of time. And how is the job still there for you when you still did not join the company for more than 1 year? So definitely all these things should be answered if there is a clear explanation, clear answer for all those things. And if the company still wants you at the same location, same position though, you may be able to, but definitely go through an immigration lawyer, make sure everything is done before. And there are certain port of entries that you need to avoid. I would say definitely Abu Dhabi, Chicago, and probably I'll throw in a couple of things, Boston, Atlanta, and Seattle. They're also becoming a little bit tougher right now.
Samrat says, I have an approved EB2 I-140. Can I also apply for an EB2 NIW? And if yes, how can I contact you? Yes, absolutely you can. And there is benefit to that, even though obviously you already have an EB2 I-140. So why would you file another EB2? With NIW, it makes you a free agent because you're no longer tied to an employer when it comes to your green card process. You can change companies multiple times. You can use that approved I-140 to extend your H-1B beyond the 6-year limit, and you don't have to have a new company start the process over for you again because you've self-sponsored your I-140. So in our office, Ryan Wilk would be the person to contact. If you go to rnlawgroup.com, you can set up a consultation with him where he can do an assessment to confirm whether you can qualify for the EB2 NIW category and what are the chances of approval. Are there things you can do to strengthen the case? And then he can help you with the filing as well.
A person who's outside the country with an approved H1B and I-140, can they come back with an H1B amendment? The main question here is that do they already have a stamping valid? If they don't have a stamping valid, and if they are filing an amendment, if they're outside the country, $100,000 is applicable. So yeah, if the company is willing to pay that $100,000, then they can come back. But if they don't, which most of the companies I know, they said they don't want to pay the $100,000. I don't find any company at this point of time that is willing to pay the $100,000.
A says, I need to transfer from H4 EAD to F1. Are these cases getting approved during the government shutdown? Yes, they are. And yes, you can file them. So you have to get an I-20 from the school. That's done through the CVIS system. That is up and operational even during a government shutdown. And then you're filing the case directly with USCIS. There's no Labor Department involvement, which means that USCIS can process everything. You can still process it in premium processing. We are still getting approvals of these cases even during a shutdown, no issues at all.
Nitika Pulsani has this question. You're advising people for change of status to B2 from H1, especially when the LCA is not available. Is that B2 better or is the H4 better? Well, let me take back though. If the H4 option is there, definitely H4, no questions about it. It is H4, H4, and H4, not B2. If you have an option of H4, H4 is better, not B2. Apply for H4, and once the H4 is pending, once you have the LCA, and you can apply from H4 to H1, H4 to H1, even when the H4 is still pending.
Rum says, my wife is on H1, which is valid until 2027, but she also filed a change of status to H4 and H4 EAD, requesting an effective start date of November 1st. We've been waiting for 4 months now. Can she still work on her H1 after that requested start date of November 1st if the change of status is still pending? Yes, she can. The H1B remains valid as long as she's working for the company that sponsored her under the terms and conditions of the H1B. The change of status to H4 does not take effect until it's actually approved. So she doesn't have to worry about being in H4 or anything like that while it's pending. She can choose to work based on her H1, or she can choose to not work based on the pending H4. Either one is fine.
Mr. Shah from X and AP from YouTube, seems to be the same person, is asking the question, is O1 and EB1 a good option, is an alternative for the 100K? I'm assuming that you're outside United States. If you're within United States, the $100,000 is not applicable. If you're outside United States, definitely O1 is better option than H1B because who is going to pay the $100,000 fees? Yeah, O1 and EB1A has been are much better options if you're outside the country. If you're inside the country, H1B is a good option too. Sometimes H1 is more advantageous than O1 visa. So if you're outside the country, definitely O1. If you're eligible for it, you're saying that you seems to be eligible for it. So if you're eligible for it, O1 is much better option than that of the H1B.
SP Kathir says, if a change of status from H1B to B2 is pending, wouldn't filing a change of status back to H1B require consular processing, which would, of course, then require the $100,000 fee? No, we are able to file a change of status back to H1B from a pending B2 and get them approved with the I-94. We've done it routinely for several years, even before the shutdown happened. That used to be the case many years ago, that you would not be able to file a change of status and get it approved from a pending B2, but now we have been able to do that for quite some time, and I don't see that ending in the near future.
Um, Kush Singh is asking that there is a DUI for him, and the company lawyer is asking that if Reddy Neumann can draft a memo and give it to him so that they can submit it. Yes, we are willing to. You can have a consultation. When you do the consultation, make sure you provide all the documents of DUI, and we can draft a memo. We can give a memo to you so that you can submit to the immigration lawyer to submit your 485 application. Yes, we do that very frequently, though.
G says, my termination date due to layoff is October 31st, but I already have the job offer from my new employer. I'm on H1B with an approved I-140. What are my options at this point? Well, you have time, so that's good. So if your termination date isn't till October 31st, you have till the end of year, December 31st, in order for the government to reopen to allow you to file the H-1B transfer on time. If the government doesn't reopen by December 31st, you'll want to look into the option of filing the change of status to B2 and then requesting an extra 6 months. That will give you more time for the government to reopen, get the certified LCA, and then have the new employer file a change of status back to H1B instead of an H1B transfer.
Maybe I want some debate. This question is raised by Satya Anil. He's asking the question, hey, the $100,000 sunsets on September 2026. Is that correct statement? What do you expect after September 2026? Because H1B lottery doesn't begin until, the start date doesn't begin until October 1st of 2026. And before that, though,
Yes.
Emily, have you seen
Uh-huh.
anybody paying? Did you heard? Did you got noticed anybody who paid $100,000?
No, never heard of anybody paying it, but I have heard of people getting RFEs asking for the fee when they are filing cap exempt petitions for people who are outside the US. They've just started coming in. So yeah, the timing of the whole announcement and when it ends is really odd. It makes no sense. If they didn't intend for this really to impact anyone until next year's lottery, why did they announce it in September 2025? And then why would they make it end in September 2026 before people have to enter on the H-1B? Um, that being said, the fee payment is due at the time of filing the petition. So if a company is going in planning to file for someone in next year's lottery after they got selected and they're planning to file consular processing, they're supposed to pay that fee up front, even if later, by the time you're entering on October 1st, the proclamation has sunset. Now, my guess is that they're going to look at this. I think they said after 4 months, they were going to consider whether to extend it. I suspect they probably will, unless there's the lawsuit blocks it. So I don't think this is the last we'll have heard of that $100,000 fee or some kind of entry ban. Um, based on the lottery. I don't know what your thoughts are on that.
Yeah, I don't think so. The administration intended to end in September of 2026, Emily. I definitely think so. They are going to extend it beyond September 2026. So if somebody is planning to say, okay, I'm going to go and come back after September 2026, not a good idea. You better stay in the country, don't leave the country. So that's definitely not a good idea. Question from Haripriya. That's a very good name. I like that name because I'm from that village. The name is Haripriya. So that's a village that I'm from in Warangal district. Can H4 and H4 EAD be applied at the same time? Absolutely. We strongly recommend to apply H4 and EAD together to have a chance to get the approval at the same time. So definitely. Also, is there a way to do H1B transfer during this government shutdown? No, because as Emily has pointed out, the LCAs are the trouble. If the LCA is there, we could have done the H1B transfer, but since the LCA is not there, we can't do the H1B transfer. So you'll have to wait for the government to reopen.
Let's see here.
Sonali is asking the question.
Himanshu's, sorry,
Go ahead,
go ahead.
Go ahead, Emily.
Himanshu says, what will happen to birthright citizenship? Will it stay for H-1B holders? So that we are going to have to wait for a decision from the Supreme Court, and that will determine going forward whether the children of H-1B holders born after that decision will be considered citizens if they're born in the US, or if they will be considered H-4. I think that there is a lot of support for birthright citizenship being allowed as is based on the Constitution, which is the supreme law of the land. So I would be quite shocked if the Supreme Court came out differently on that, but it will be eventually up to the Supreme Court.
Emily, the next question that is coming up, will it make a difference between the blue state and the red state? We don't consider that at all because once the Supreme Court gives a decision, though, it will be applicable across the nation. It definitely will not be that if you are in Texas, you won't be given citizenship. And if you are in California, you'll be citizenship. I don't think so that will happen. Do you agree with me, Emily?
Yeah, I 100% agree with that.
Okay. 1 second.
A couple of people are asking about the national interest exemptions for this H-1B $100,000 fee. There is no blanket exemption that has been issued, so it is up to each individual company to submit that. I know attorneys have submitted requests to the email address, and as far as I'm aware, as of today, no one has gotten a response, not even a confirmation email that they received the request. And we don't know what the adjudication is going to look like. I suspect it's going to be very hard to get a national interest exemption. They made it pretty clear in the announcement when they updated the guidance that these are meant to be very limited and extremely rare.
Himanshu is asking this question. Is it better to move if you are a layoff on to B2 or to F1 and then afterwards from B2 to H1B or F1 to H1B, which is better? Well, B2 gives only 6 months of life in the United States, though. Then you have to extend it. Definitely, we are seeing some RFEs when you're filing an extension of the B2 after the 6 months. That means the first 2 months you don't have a job in 60 days, and then afterwards you have 6 months and you don't get a job in 8 months. You're filing an extension. We are seeing problem. We are seeing a problem for the B2 extensions. But B2 to H1B is not a problem. We have not seen any problems. There are some RFEs, but if they are responded properly, we get the approvals. F1, instead of giving a way only for 6 months, F1, you can stay for a long period of time in F1. That's a great advantage. From F1 to H1 also, we don't see any problem. But F1 is, you can stay for a lengthier period. Of course, it's going to be, if more costly for you to study and go to college and pay the fees. That's a disadvantage, but you get a lengthier period on F1 visa.
Lasia says my 485 was filed 3 years ago, but then the dates retrogressed, and now my date of filing is current. I-140 is approved. Am I eligible for CSPA protection? That's Child Status Protection Act. So it is very difficult to determine based on the limited information that we have. We need to know, was your I-140 and 485 filed concurrently, or was your I-140 already approved when you filed your 485? At the time you filed your 485, which rule was in place when it comes to the Child Status Protection Act? Because we had an old rule and then we had a new rule that allowed us to use the filing dates in some months, but not every month. And then we have the old rule again, which took effect recently. So depending on which time period the 485 was filed and whether it was a concurrent filing or not, and how long it took the I-140 to be approved if it was a concurrent filing, we need all of that information. Basically, for the Child Status Protection Act to apply, you need to have an approved I-140, and the final action date needs to be current unless you filed it at a time where they were accepting the filing date being current to qualify. So it's a very complicated area, but if you want someone to look into that for you, do an assessment, you can certainly set up a consultation with any of the attorneys in our office.
Do Canadian citizens need to pay $100,000 fees? Yeah, if that is an H-1B that you're filing, you are subject to $100,000 fees. I would avoid it because TN visa does not require the $100,000 fees. So most of the H-1Bs will be eligible for the TN visas also. So since you are a Canadian citizen, I will try to avoid the H-1B and pay the $100,000 fees, which I don't think the companies are willing to. So definitely, if you are outside the country, I would go with the TN visa rather than H-1B.
Venkatesh says, it's been over a month and I haven't received a decision regarding my 221G. Is there anything that I need to know, and how long will the process take? 1 month is not very long when it comes to 221Gs. Many times they are pending 6 months, 7 months, 8 months before you get a decision on that. What to know about it? It is considered a denial until they later decide to approve your visa, if they do. And if they didn't request any documents from you, there's really no way to know what the issue is that they're looking into. Could be security check, it could be they're checking into the end client, checking into the validity of the documents that were submitted. Could be just sitting on someone's desk while they're waiting to make a decision on it. And there's not really a whole lot that can be done. I mean, you can continue to send email follow-ups or use that Visa Navigator form, depending on which consulate it's at. Sometimes we need to use litigation in order to get it moving. That's usually once it hits the 6-month mark, but it could be an extended period of time before you hear back.
Venkatesh is stuck in Mexico with 221G.
Oh, that must be the same guy.
Oh, sorry.
I didn't realize it was in Mexico. Yeah, he may have to go back to his home country unless he
Yeah,
wants to wait
that's
in Mexico
but
for six
when
months.
that rule came a couple of months ago that you can't get the stamping in Mexico, or you can't get stamping anything outside the home country. So this guy is stuck for a
Mm,
long period of time in Mexico.
yeah,
That's definitely I would go to home country.
yeah. Well, I think we're out of time for today. Thanks everyone for joining us. We'll be back next week with all the latest updates to keep you informed of what's going on with business immigration. Please subscribe to our channel, subscribe to our newsletter so that you can stay on top of everything and make informed decisions about your immigration.